Hello, my name is Alex Rutkew. I'm a barrister at 39 Essex Chambers specialising in mental capacity law. In this episode of the Shed Now series, I want to go through with you the guidance published by the Department of Health and Social Care on the 29th of May relating to MCA and DOLS. Guidance additional to that published in April. That guidance I've discussed previously in a previous episode of the Shed Now series. The link for that you can find on my website. This episode, I just want to flag up a few additional points that the Department of Health and Social Care has addressed, and again draw out some key themes and little points which the guidance itself does not discuss. So without further ado, I'm going to pull up the guidance on the internet and we can go through it together. So this is the guidance here. You can find it here just to show you where it is. It sits here. Guidance, that's the main guidance. But the stuff I want to talk about here is the additional guidance published today for the first time, 29th of May. So the first aspect is thinking about testing someone who lacks the relevant mental capacity to consent. This is really important because testing is going to form such an important part of releasing lockdown, and also because testing has become such a central feature of how the government is seeking to respond to the crisis of COVID-19 in care homes. One critical thing, of course, and the government makes clear, DHSC makes clear, is first and foremost, can you support the person to take their own decision as to whether or not they want to be tested for COVID-19? Then, as the government makes clear, you can see here, best interest decisions, if the person can't be supported to make the decision, have to be made on an individual basis. You can't simply have blanket policies saying everybody is going to be tested if they lack capacity, and we're not going to think it through. We've done a lot of discussion and a lot of consideration in chambers about best interest decision making in relation to COVID-19. You can find on my website a link to that guidance. This guidance, I should say, is entirely in line with what the shorter version that the DHSC puts up here. And I should say, of course, you need to follow what the DHSC says first and foremost. But one of the critical points here is thinking through best interest decision making. So often it is going to be able to identify that the person themselves would have wanted that decision to take place, would have wanted testing to take place, including the idea that they might well have wanted that testing to take place in the interests of others. They wouldn't have wanted to spread COVID-19 if in case they had it. There's a very interesting case about the Skripals, Sergio and Yulia Skripal, which talked about the idea of the responsible citizen. In other words, the person wanting to do the right thing. One thing I should say that this guidance doesn't talk about here in relation to best interests, and is quite edgy, is the circumstances in which it's clear that the person might not have wanted to be tested. The fact that they might not have wanted to be tested, of course, doesn't mean it isn't necessarily in their best interest to test, because best interest is not quite as simple as what he would have done, what the person would have done, and there might well be good reasons why, notwithstanding the fact that actually you would have known the person would have wanted to be tested, it's still in their best interests. If, though, it's clear that the person not only would not have wanted to be tested, or would not have understood what testing, simply can't understand testing, and would be distressed and potentially require restraint in relation to testing, to bring about testing. Guidance doesn't talk about this, but please can I flag, you need to think about this very, very carefully. Not just because legally restraint becomes edgy, especially if the reason to restrain the person to carry out the test is not in their interests, but the interests of other people, but also because it becomes edgy if we're carrying out restraint for people if it's not necessarily going to change what treatment they're going to receive. Guidance touches upon this here, that for instance, testing can potentially make a difference as to what treatment the person receives, but it may not necessarily. And so can I please flag for anybody reading this guidance, if there's reason to think that, for instance, somebody with autism is going to respond badly to the swab test, which might be the one which is carried out, and might require, for instance, physical restraint and might become agitated, that's a circumstance under which very serious consideration needs to be given to, in the first instance, seeking legal advice and potentially going to the Court of Protection for an order there. So that's testing. Deprivation of liberty and life-sustaining treatment. This is very helpfully amplifying the guidance which was given in April, reinforcing the idea Department of Health is making clear, Health and Social Care are making clear, the so-called Ferreira exception for the delivery of life-saving treatment not amounting to deprivation of liberty may well apply in care homes as well as hospitals, but critically, if only if further measures are not being required over and above those which would be required for anybody. Useful application here in terms of advanced planning about life-saving treatment. Please reinforce this idea that advanced planning must always be done with the person, not to the person. Can't emphasize that enough. Advanced care planning is incredibly important, really necessary, but it must always be done in conjunction with the person. And if the person doesn't have capacity to participate in the process, it needs to be done in conjunction with people who know and are able to give information about the person's wishes, feelings, beliefs, and values. For instance, by way of a respect process. And then just a useful point there, just reinforce something people don't always remember. Who can refuse life-sustaining treatment? A deputy can never refuse life-saving treatment. They can consent to it, but they can never refuse to it. And an attorney can only refuse life-sustaining treatment if the donor has specifically given them that power to do so in the power of attorney. I'm not going to talk much more here about what the guidance has done in terms of interpreting the acid test, although it's useful just to remind us that not free to leave here means not free to leave the accommodation place permanently. Just pack your bags and go. And I'd reinforce, if you're not free to pack your bags and go, then it's going to be a very unusual situation in which you're not under sufficiently continuous supervision and control for your circumstances to amount to confinement. If at that point you can't consent to the confinement, and the state knows or ought to know, we've got a deprivation of liberty. If you want to know more about deprivation of liberty, I did one at the Shed on our series about the fundamentals of deprivation of liberty, where I talk more about this. Reminding us there of the importance of advocacy, importance of IMCA and RPR advocacy. If we don't have advocacy, people are really losing their rights. That means also that bodies need to be able to facilitate IMCAs and RPRs being able to carry out their roles, even though, as the guidance makes clear, it's for the majority of time going to have to be remote techniques. We've talked that this guidance here, I'm not going to talk about in much more detail because this is really reinforcing this idea built in the main guidance in terms of thinking about where DOLS authorizations are already in place. In terms of discharge, just reinforcing this point here, really important, best interests. Best interests are the choices between the options which are actually available for the person. Those options might well be constrained at the moment. In particular, they might be constrained at the moment by complexities in terms of, for instance, making assessments under the Care Act, meeting needs under the Care Act, although, please, 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 only easements in relation to the Care Act under the Coronavirus Act are only relevant where they have been activated by the relevant local authority. But if options are the options which are actually available, the choice between the options which are actually available at the best interest decision making, one point here, of course, and the guidance doesn't need to say this because it's so clear, if circumstances change so that more options become available, you need to reconsider best interests. Best interest isn't fixed for all time, simply by a one-off decision. There, again, discussion thinking about outside the MCA, outside DOLS rather, in terms of thinking about MCA decision making and the circumstances when a deprivation of liberty might arise. And if there is a deprivation of liberty, need to apply to the Court of Protection. Please, can I emphasize this point here? If you have not applied to the Court of Protection, you have no legal cover, you have no legal authority to deprive the person of their liberty. It is only when you have made that application that you are potentially covered by Section 4B of the Mental Capacity Act, and you're only covered by Section 4B if at all times you need to deprive the person of their liberty, either to carry out life-sustaining treatment or to prevent a serious deterioration in their condition. Useful application there, I'm not going to go back over, but this is rehearsing the stuff about DOLS assessments. and when it's possible to reuse an old assessment or to make use of an old assessment for purposes of drawing up a new assessment. Prioritisation. Please can I emphasise one point here in terms of prioritisation. One massively important issue about authorisations is that they give the right to non-means tested legal aid to bring a case to the Court of Protection, non-means tested legal aid for the person. If no authorisation is in place, the person only has the right of access to means tested legal aid, which means that many, many people would not get legal aid at all. Unless there's an authorisation in place, the person does not get legal aid. And if the Court of Protection is considering somebody's case under Section 21A of the Mental Capacity Act, they can extend the authorisation, but they can only extend it for a maximum of 1 year. And so if the Court of Protection is considering someone's case and a local authority is coming up to a position where it's thinking this authorisation is about to expire and it's a 12-month authorisation, please, 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 if you're working for a local authority, it is necessary to make sure that there is a fresh authorisation in place. Because at that point, the person continues to maintain their right to non-means tested legal aid in the context of Section 21A. If the local authority doesn't prioritise renewing that authorisation, then they lose the right to non-means tested legal aid, and there's a very substantial rights problem that arises at that point. So whilst I completely understand prioritisation, prioritisation must not give rise to a deficit in somebody's rights, especially where a case is already before the court. Here we've got some important and very useful guidance in terms of the interface between the Mental Capacity Act and emergency public health powers. I should say these are powers which people are finding really quite challenging to understand at the moment. These powers here are powers under Schedule 21 to the Coronavirus Act. They're powers which operate in England, they're powers which operate in Wales. I've written quite a bit about this, you can find on my website looking at the Coronavirus Act powers. One thing it is really important to understand is in terms of public health officer powers, you can see here, the public health officer actually has ultimately really very limited powers to enforce the decisions that they make. If the guidance is absolutely correct that the public health officer powers can include telling the person to, for instance, be tested and requiring them to be isolated, but what they can't do is actually bring about enforcement except by a constable, a police officer. And it's going to be so rare in almost every single case for it to be appropriate for a constable to be seeking to enforce restrictions, for instance, by way of isolation on a person with impaired decision-making capacity. In fact, it's so rare I can't sensibly think of any circumstances where that is going to, in fact, be the right thing to do. So if one is talking about people with impaired decision-making capacity, my very strong steer, lining up entirely, I should say here with the DHSC guidance, is the Mental Capacity Act needs to be considered if at all possible, and if it's reaching beyond the remit of what, for instance, could be done in the name of DOLS, it's going to be the Court of Protection which needs to be looked at rather than public health officer powers, because the Court of Protection could authorise a regime of deprivation of liberty, for instance, including by way of isolation. The Court of Protection could authorise relevant individuals also to enforce that regime. Because, to reiterate, public health officers might well be able to, as it were, make legal a deprivation of liberty for purposes of isolation in some circumstances, but they can't bring about the enforcement of that in any practicable fashion. So this is my summary of some of the key points in this additional guidance. It's extremely useful that this guidance has been issued. It is extremely useful that the Department of Health is continuing to keep this under review, and hopefully in due course further iterations can be brought out as well to respond to further issues that people come up with. Thanks very much indeed for listening.